Kolhapuri chappals, Banarsi saris, Madhubani paintings, Darjeeling tea, and Malihabad mangoes. All of these products have one thing in common: geographical indication, a tag which indicates that these goods are actually recognized and identified as being produced or manufactured in a particular region, which in turn makes them all the more valuable for customers. Hello and welcome to The Print. This is Khadija Khan from New Delhi, and I'm here to tell you about a recent ruling of the Delhi High Court in a legal battle between the republics of Chile and Peru over the geographical indication, or the GI, of an alcoholic beverage called Pisco. Now, Pisco is a type of liquor derived from fermented grapes by distilling them according to traditional methods. But first, let us understand what GIs are. Essentially, GIs, or geographical indications, are used to indicate the regional origin of particular goods, provided these goods derive their particular characteristics from their geographic origin. Such goods can either be man-made or natural. For instance, Feni, a traditional spirit that originates in Goa and is derived from either cashew apples or coconut sap, is an example of a man-made GI, whereas a Dasehri aam, which is an illustration of a natural GI, originates from Uttar Pradesh. In India, such geographical indications have been defined under Section 21E of the Geographical Indications of Goods Act 1999, which in a nutshell says that particular goods are manufactured or originate from a particular territory, country, region, or locality and possess some special quality, reputation, or characteristics which are essentially attributable to its geographical origin. This is also why certain goods are highly prized due to their origin in specific regions, such as pashmina shawls or champagne, which hails from the Champagne region of France. Now let us break down the Delhi High Court's recent order. By way of a 47-page ruling, Justice Mini Pushkarna noted that since the alcoholic beverage Pisco from Chile is also recognized and identified worldwide, just like the Pisco that originates from its neighboring country, Peru, the latter could not claim exclusivity over its geographical indication tag, as that would be detrimental to the legal and legitimate commercial interests of Pisco producers in Chile. It could also deceive consumers and cause confusion, the court noted. In doing so, the court set aside a 2018 order passed by the Intellectual Property Appellate Board, or the IPAB, which is a quasi-judicial body that exercises jurisdiction over trademarks, patents, and geographical indications, where it had allowed Peru's application for claiming the GI tag over the alcoholic beverage. Before this 2018 order, the Assistant Registrar of Trademarks and GI in 2009 had granted Peru the GI tag, which specifically said Peruvian Pisco. But this was later set aside by the IPAB after a span of 9 years, while giving the exclusive GI to Peru for the use of the term Pisco. Challenging this, the Asociación de Productores de Pisco, Chile, approached the Delhi High Court. It argued that the Peruvian Pisco should specify that it is Peruvian, while the Chilean one should specify that it hails from Chile. While the Chileans did not dispute the fact that Pisco can also originate from its neighboring country, Peru, they argued that the Pisco liquor that emanates from Chile is different from the one that originates in Peru. The differences lie in the types of grapes used, the processes used to make them, and so on, they argued. Now let us take a look at the competing claims of the two countries in this case. The Chileans argued that Pisco hails from the river valleys of Elqui, Limari, Huasco, Copiapo, and Choapa. The producers of the Chilean Association have been producing and marketing Chilean Pisco for well over a century, they said. Chile argued that the production of Pisco was carried out extensively and continuously, and that there are historical and geographical links between the two countries. On the other hand, Peru argued that there was a huge inordinate delay in the time it took Chile to come to the court, challenging the 2018 order. They also argued that the Chilean Association had itself admitted that Peru has a right over the Pisco GI. Interestingly, the Peruvians also pointed out that the Chilean congressman González Videla, who later served as the president of the Republic of Chile, promoted a law in the Chilean Congress in order to change the name of a city from La Union to Pisco El Cuy in 1936, terming this as a despicable measure to illegally benefit from the reputation of the Peruvian beverage. They said it is undisputed that Peru is the producer of the beverage. Referring to the contours of the 1999 Act on the subject, the court said that the GI Act provides for registration and better protection of geographical indications. They aim to protect the interests of consumers and producers and exclude unauthorized persons from misusing GIs, it said. However, the court recognized that Pisco produced in Chile is distinct from the one produced in Peru and that the two countries can coexist in the realm of Pisco production. And that brings us to an end of today's segment. For more legal updates, keep watching The Print with me, Khadija Khan.